This is episode 432 of the Rio Grande Foundation's Tipping Point, New Mexico. I'm Paul Gessing, president of the Rio Grande Foundation, New Mexico's free market think tank. You can find out more about the foundation at riograndefoundation.org. I am very pleased to be joined for this week's episode by Caleb Kruckenberg. He is an attorney at the Pacific Legal Foundation, which is, broadly speaking, also a free market organization that deals much more on the legal side of things. Welcome to Tipping Point, New Mexico, Caleb.
Thank you.
Yeah, and we're going to talk about a lawsuit that your organization's brought against the Biden administration regarding charter schools. We're going to talk about administrative law and Chevron deference and all kinds of exciting things for those legally minded out there as well. But before we get into that, talk a little bit about yourself and the Pacific Legal Foundation. And before we got started, you said you'd lived 3 years in Las Cruces. So let's check off all of those boxes while we've got the chance here.
Yeah, absolutely. So I work for the Pacific Legal Foundation, and we are a nonpartisan, nonprofit litigation firm. And we file a lot of lawsuits. We also defend people when they are the victims of government overreach. And I think it's very accurate to describe us as free market, pro-freedom organization. I mean, anytime we have a government actor that is going too far, particularly when they're interfering with someone's right to earn a living or live the good life that they want to live, we step in and we provide pro bono legal services. But kind of going back to what you said, yeah, I used to live in Las Cruces. I spent 3 years down there, and I live in Virginia now, and I really miss New Mexico on those cold, rainy days in the fall and winter.
I bet. Now, you said that you were a public, let's see, public defender, or you worked on the defense side of things, and
Yeah,
that's
so I
kind
I
of
was
unique
a
for free market people, would you say?
yeah, I think so. But I think one thing that I learned, so as you said, I was a federal public defender down in Las Cruces. And one thing that I saw that really stuck with me is just day in, day out, the government cheating a little bit. They were going too far. And sometimes they do it in criminal cases. That's one thing. But there are government actors in every corner of our lives, and they do the same thing. They cheat, they cut corners, they go too far. And it's really just over and over again, the government is really trying to stop us from living the lives that we all want to live and we all should live. And so I think it was a really enlightening kind of a process for me.
All right. Well, let's get into the subject at hand. And you can fill in the gaps, but broadly speaking, Rio Grande Foundation and a lot of other groups several months ago provided public comments. The Biden administration had proposed at the time some restrictions, if you will, on charter schools. And here in New Mexico, as you may be aware there, Caleb, uh, the only real form of school choice is charter schools. I mean, we have magnet schools and whatnot, but charter schools are really the only school of choice sanctioned by the state of New Mexico. And so that's an issue that we care quite a bit about. And with the Biden administration attempting to limit the schools and make them jump through all kinds of new hoops, we worked with some education reform advocates in opposing those. But it was a public comment process, and that process ultimately leaves things in the hands of bureaucrats and politicians. In this case, in the Biden administration, who have a philosophical problem with charter schools, and they put those charter school regulations in motion, and that's kind of where I sit in terms of where things stand. But I know your organization and you personally are involved in suing on behalf of charter schools. So fill in the gaps that I missed there with regard to some of those policies and actions.
Yeah, and this is an important issue, I think, that affects anybody who's interested in school choice in general, charter schools particularly, because I like to call it a sneak attack on charter schools. Because just taking a little bit of a step back, Congress set up the charter school program. It's a federal program. It's supposed to allocate a very significant amount of money every year that goes to starting up or expanding charter school programs across the nation. And it applies anywhere there's a charter school. And this program had one very clear goal: get the funding out there, make it as simple as possible, and fund high quality, good programs that give kids an educational option. The Department of Education, though, as you said, they don't have a philosophical they're not in agreement with the whole concept of charter schools, because they're set up by President Biden, who doesn't like charter schools. So his Department of Education, his Secretary of Education, came up with a rule that looks like it's supposed to administer these grants, but really it's designed to make sure the money doesn't go to new charter schools, and it really disadvantages the ones that do the best job. So, once this rule finally went into effect, we stepped in as soon as we could, and filed a lawsuit. We represent an organization in Michigan, as well as an organization in Ohio. That the organization in Michigan is basically the coalition of all the charter schools. The one in Ohio is one that works with a lot of charter schools, and we're trying to stop it because, like I said, it's really an effort from the administration to interfere with the program that Congress set up.
Right. Now, so talk about some of those specific rules that have been pushed forward by the Biden administration. And given that education still remains, by and large, a state priority, uh, is this inherently conflicting with state rules? Could states just tell the Biden administration to take their education money and go elsewhere? How does this all work?
Right. So as far as funding is concerned, right, theoretically, a state could just tell them, we don't want to cooperate. The problem is, this is a tremendous amount of federal education dollars. And, whatever our larger view about who should be funding public education, this is a pot of money that's been set aside for one specific purpose. And, this year it's $440 million. And it's supposed to just go to charter schools to open up new programs. The new rule, though, there's a lot of problematic aspects of it, but there's three specific features of the new rule that are very concerning. One is what they call a cooperation requirement. And what they mean is a charter school has to show the department in an application for a grant that the traditional public school district is going to cooperate them. They have to give specific commitments and a timeline. But the problem is a lot of local school districts don't like charter schools. They resent them because they view them as competition for dollars. And a lot of them will refuse to cooperate. They're very hostile to charter schools in general. And what this allows is the local school district can effectively disadvantage the charter school applicant by just saying, we're not going to cooperate. Another aspect is what they call a needs analysis. So the applicant has to show there's a need for the new charter school, but the way they measure it is they look at the existing school district and they see whether there's space in the schools. So they say an applicant needs to point to the school and say it's overcrowded, therefore we need a charter school. But that's not what charter schools are for. they're educational alternatives. If you look at a lot of school districts like Detroit or New York, public schools are, there's plenty of space there. That's not the problem. The problem is they're not performing. And finally, there's what they call a racial isolation requirement, which they say that if you're an applicant and you have a school that will increase racial isolation in either the school district or the charter school, then they're going to disadvantage your application. And what they mean by that is if you have too many students in one particular ethnic group. But again, if you think about a lot of charter schools, look at Detroit, for instance, where some of our clients have schools. That is a predominantly African-American community. And charter schools, unsurprisingly, serve a very large number of African-American students, but they are racially isolated, at least in the view of the Department of Education. And therefore, once again, that disadvantages their applicants, even though those are the schools that we want to be funding because they're doing good jobs for students who need the most help.
Wow. It seems hard to believe that with all the challenges this country faces in educating its students that there's a political attack on them at this point, especially given that charter schools have been around for several decades. I want to have you take off your attorney hat briefly and put on your political science hat. Is this purely just you think a teacher union driven thing within the Biden administration that they're trying to push back on this educational option that doesn't maybe favor the unions, or is there something else at play here? Because it seems pretty hard to fathom that this is the actual argument that they're making, these kind of racially disparate arguments, especially when it comes to charter schools.
Well, if we look at President Biden on the campaign trail, he said, quote, he's not a fan of charter schools when someone asked him. And the reason he said is because they're anti-union. That was his rhetoric. So we know how he thinks about this. And, he has appointed the Secretary of Education. It's his Department of Education. And I think there's two ways to look at charter schools. What I think is the correct way is to see it as this is an innovative alternative that promotes competition. And if a public school is not doing its job, here's an alternative parents can choose if it serves their needs. And hopefully that makes everybody work harder. It makes things better, right? Competition is great. We compete with each other and we all win. The other way to look at it is to say new competition steals our dollars away from us because we're entitled to students, we're entitled to funding, no matter how awful we are. And I think, unfortunately, the administration has embraced that latter kind of a view. They really resent charter schools, even though Congress set up this whole program because they recognize the importance of these schools, the importance of these alternatives to parents.
Now, let's get into the legal arguments and kind of the legal case here, because you recently filed suit on behalf of your organization and are taking on this issue. So talk about some of the mechanics of that and what kinds of arguments you plan to make in this case.
Well, probably the most important and the most basic argument we're making is about what role the Department of Education has at all in this program. Because Congress set it up, they set it up pretty clearly, and they didn't put limits on the kinds of programs that should apply or schools that should apply, other than they're just successful. But the Department of Education has come in and they said, actually, we have this secret authority that Congress never mentioned to issue new rules, and we can put whatever conditions we want on this money and make the charter schools jump through whatever hoops we can devise. but that's not the way the law is really supposed to work. I mean, if Congress says one thing, the agency can't say another. That's theoretically the way government's supposed to work. But the agency, I don't think, really is bothered by those kind of legal niceties. And so our primary argument is just there's no role here for the department. They can't issue these kinds of rules. But even if they can issue rules in general, they can't issue these specific rules. Because the second argument, I think, is if you look at them, as I just explained, they are trying to undermine the program. They're not trying to advance it. And again, that's not something an agency is allowed to do when it's merely administering a congressionally set up program.
So this gets into administrative law and something that, again, attorneys out there, their little hearts might be beating faster on hearing that kind of thing. But a lot of people may feel a little bit lost when it comes to what that actually means in practice. But just to kind of recap, as you said, Congress has passed a law, and that law had been in effect more or less implemented as Congress said. Can you tell me approximately when that law was passed? And what it said, broadly speaking?
Right. So the original program was started during the Clinton administration, and which is somewhat of an irony there, but it was signed into law by President Clinton. He set up the program, or his administration signed off on it, and it was significantly expanded in 2015 during the Obama administration. And what it said basically was the goal of the program is to increase access to public charter schools by expanding them or replicating high quality programs. And the conditions or the requirements were it to be a quote unquote high quality program, which is measured by academic success. That's it. That's what the Department of Education, when they're administering the funding, that's what they're supposed to look at. Do these programs serve the students? Do they do a good job?
And now you have administrators at the U.S. Department of Education, which are using this concept of administrative law to change what Congress said, or at least that's the impression I get. And it seems like, based on recent Supreme Court decisions, that the U.S. Supreme Court has finally had enough, and they are going to be pulling back or pushing back against the idea that unelected bureaucrats can essentially change the law in ways that they want, which generally means more power for them, less power for Congress, and less power for the American people. But let make that intellectual transition for us from just the charter school area, which is very important and something that we want to explain to people what's going on. And we'll talk about the kind of timeline of the case, et cetera, what courts you're in a minute. But let's talk about that transition into the administrative law.
Yeah, well, I think what's important about the charter school case is it really is a good illustration of the kind of damage that the administrative state can do. That this is what kind of thing can happen when a bureaucrat steps in and they think they know better than Congress. And, this is really what my work at PLF focuses on just across the board. I deal with administrative law issues. And so I really litigate a lot of cases against administrative agencies when they are trying to interfere with the other branches of government that they're not supposed to. Administrative agencies they're not really supposed to even be part of the government. They're just supposed to be an aspect of the executive branch that is just supposed to figure out certain details, administer certain programs. But as the government's gotten so much larger, these agencies have taken an outsized role, and sometimes they interfere with judicial roles, sometimes they interfere with legislative roles. And I think Congress has allowed this to happen over the past 30, 40 years. They've kind of taken a back seat and they've allowed agencies to do a lot of the real work. But we're fortunate that the Supreme Court currently has recognized the harm. And, we finally have a majority of the court that is willing to rein it in. They're willing to rein in the influence of administrative agencies in the courts, and also, the role when they're interfering with Congress. And there was a case over this summer that I think is a very important signal about what the Supreme Court's thinking. It's a case called West Virginia versus EPA, which a lot of people have probably heard of, but primarily this is an administrative law case. That was a case that dealt with the EPA and how much authority they had to interfere with, to issue new environmental regulations that are aimed just broadly at global warming. And the court, I think, took a very clear message that they said, we are no longer going to let agencies step into major questions, important issues, and just make it up and write laws on their own when it's not clear that Congress wanted them to do that, when there's no clear direction from the legislative branch.
Now, correct me if I'm wrong, but the West Virginia versus EPA case had to do with the Clean Air Act, which was last updated in 1990, and efforts that the U.S. EPA and both the Obama and Biden administrations had been making to force or use the EPA to force states and businesses to comply with their CO2 initiatives, while using this old law that was passed long before climate change was really a discussion, CO2, et cetera. That's the gist of it, right? Kind of using a pre-existing legal set of standards and policies to apply to unrelated topics.
Right, and this is something that comes up constantly. If you look at a lot of laws that Congress passes, and this is kind of their fault, they have a lot of blame here, but Congress loves to do things that they'll, especially a long time ago in the 30s and 40s, they really like to do this. They would pass a law that says, and some agency can do whatever is necessary and appropriate under this law. And they would just kind of leave it at that. And the agencies have a really bad habit of saying, oh, well, that allows us to do literally anything we can think of. We don't like greenhouse gases, so we can now regulate state entities. But the Supreme Court, I think, with that case said, you know what, that's not going to fly anymore. You can't just point to this old statute that you dug up that was passed by a Congress that had no idea you were going to do this with it. And you can't just rely on that. You have to, especially when you're doing something really major, really important, and political, you actually have to point to clear authority. You can't just kind of fudge it.
And how do you think that applies specifically to the charter school issue? Connect the dots for
Sure.
us and our listeners, if you would.
Well, so if you look at the charter school program, as I mentioned, it's the statute sets aside the money. It says it has to go out. That's it. There's not even that kind of extra part of the law that says the Department of Education gets to administer it or anything. That's it. There's just nothing else. And the Department of Education, their response, their source of their ability to write these rules, they said basically, well, just look at the law. Somebody has to administer it. And that is literally their argument for why they get to pass this law. And I am quite certain that the same majority of the court that wrote the West Virginia versus EPA case, if they looked at what the Department of Education is doing here, it doesn't fly. The agency doesn't just get to wave their hands and say, well, it doesn't tell us not to, so we get to do it.
So, what is the process here? You're obviously not at the Supreme Court yet, unless you've gotten some Justice Roberts' benediction to take you past go to collect your $200. Just kidding. But what court and what area of the country are you filing in?
So we filed our lawsuit in the Western District of Michigan, which is where one of our clients is headquartered, which is the Organization of Michigan Charter Schools. And we just filed our complaint. The timeline, unfortunately, it's always slower than we would like. But our big goal here with the litigation is for the next funding cycle. So the way these grants go out, they go out every year in the summer, usually. That's the application period. The Department of Education isn't using these really offensive priorities for this year, for 2022. They are going to use them for next year. And so we are hoping that we're going to get an order from the court before then. We're going to do everything in our power, basically, to stop the grant cycle in 2023 from using these new priorities, because that is going to have a real impact on schools really everywhere if the department gets away with this.
So at least this fall is not affected, but it could be as quickly as next year. Now, Western District Court of Michigan. Again, I'm not a legal expert. Is this a state court, or this is not or is this a part of the federal court system?
This is part of the federal court system.
Okay. So you would go through the district and then possibly onto the Supreme Court if things, well, I don't know. I guess it could go either way, and you would just go up that chain of command there. So do you have a hearing date on and when this first round is going to be happening?
So we are still waiting for the government to respond. We filed the lawsuit just at the beginning of August. Unfortunately, the rules give the government 60 days to respond to a lawsuit. They get a lot more time than any normal litigant. And so we're going to see what they're going to say. I can guess. My guess is their response is that we're an agency. We get to do whatever we want. How dare you question us? That's just my experience.
Yeah.
And then we're going to litigate it.
Yeah. And it's unfortunate. There almost seems to be a method at play here where politicians pass something, no matter how outrageous or extra legal it may appear, and then they can at least get that policy implemented for a time period in anticipation of whatever the judicial system may have to say about it. And that process takes a lot of time to work itself out, and it can go either way, quite frankly. With the judiciary, you just never know. Obviously, we feel pretty good about the U.S. Supreme Court, but a lot of cases don't make their way up there. Is that a good district if you get the Court of Appeals? Do you feel good about that aspect of the case?
We do, and it's in the Sixth Circuit, which is a regional court, federal courts of appeals. But the Sixth Circuit, particularly on administrative law issues, I think is very perceptive, and they're very perceptive about they have a lot of the similar kinds of thinking that the Supreme Court does. And what I see in administrative law generally is, I think the Supreme Court has kind of gotten it. They've realized the problem, and they've really, taken a strong stance, and they've realized the harm that giving too much power to agencies can do. The lower courts have they're catching up. So I think the Sixth Circuit is a good. They're ahead of the curve. They're doing better than some other courts are. But you're right. It's the Supreme Court right now is exactly where it should be. And we're kind of waiting for the other courts to catch up.
And before we conclude, kind of the long-term legal goal of a lot of conservatives is to address or remove something called the Chevron deference, which has to do with this administrative law procedure and the idea that unelected bureaucrats can essentially make the law. Uh, yeah, I mean, there was people. Let's see, uh, Ben Shapiro, who's one of my go-tos on a lot of legal issues of the day. He was implying that there might at least be a chance that when the Biden vaccine mandate was up, that there might be an attack on the Chevron doctrine, that the West Virginia versus EPA case, which we talked about, might address that. Can you describe the Chevron doctrine and why that's such a, it's right up there, I guess, at this point now with Roe v. Wade as a legal doctrine that conservatives would like to see overturned?
Well, Chevron is kind of the high watermark of insanity from an
All right.
administrative law.
Tell me how you really feel.
Uh, from the Supreme Court. So it's a case from the early 1980s. And what Chevron says is when an agency like the Department of Education, they issue a regulation that fills in a gap in a statute, that interprets a statute, a court has to just let them interpret the law and give it controlling weight, even if the court doesn't agree with it. So it's kind of an abstract concept, but in practice, it's really dangerous because you can think of a situation where a law says, it's illegal to make unreasonable noise. And then an agency says, okay, well, this is what unreasonable is. It means literally any noise. Okay, that seems like a stretch, but that's what the agency says. If under Chevron deference, a court looks at that and they say, well, I don't agree with the agency, but they're right, I guess. I have to give it controlling weight. That's now the law, even though I don't agree with it. And what happens is it allows administrative agencies that are bureaucrats, they're unelected, they're not appointed by anybody, they're not judges. They get to tell the judges what the law means. And that is a fundamental violation of what judges are supposed to do against Article 3 of the Constitution. I think the Supreme Court has recognized that. They seem to be at least content for now with undermining Chevron and not applying it and avoiding it and sort of chipping away at it without saying its name. But it is still a dangerous and pernicious kind of a doctrine because the lower courts still use it and it comes up a lot. And an agency, basically, it's once Chevron comes into a case, we win no matter what. And that's part of the long-term strategy is try to get that out of the law and just make agencies act like anybody else. They don't get to tell a judge that we're right automatically.
Mal, just to be clear, this case probably wouldn't be the vehicle for a outright repeal of the Chevron doctrine, but it could be another tool at chipping away from it, it sounds like.
Absolutely. And, unfortunately, Chevron comes up a lot of times. It's like we keep trying to avoid it and it rears its ugly head. So we'll see. And this is all part of, I think, a broader effort to just try to get the courts to recognize that there should be actual real limits on what an agency can do. And for goodness sake, an agency shouldn't be telling a court how to do its job, but it also shouldn't be doing the job of Congress in the first place.
Yeah, well, and of course, when it comes to educational choice and the freedom of parents to make decisions about their child's educational future, it's important to have charter schools as kind of the initial, I think, reform option available. It's certainly not enough, and we see that in New Mexico, that we need more robust choice options. But thank you for defending charter schools and also pushing back against the broader issue of administrative law and the way that Congress and the intent of elected officials is kind of pushed behind what these unelected bureaucrats want to see and do. So it's great. Can you share any information about, if people want to track this particular case or find out more about the case or the Pacific Legal Foundation or both? Can you share that information?
Yeah, absolutely. So the best way to get information about this or any other case that we have is go to our website, pacificlegal.org. You can sign up for our magazine, for newsletter, and there's even a page on our website about this case, about the Department of Education's attack on charter schools. You can keep updated on this, and you can look at some of the other work that we're doing, because I wish this was it. I wish I wasn't as busy as I am, but there's always a lot going on, and we fight every day, I think, for people who have been on the wrong side of the government.
And real quick, I almost neglected to mention it. The Pacific Legal Foundation did have a case that was relatively high profile right here in New Mexico. It had to do with, I believe it was Obama's waters of the United States, and a ditch on somebody's land that was very, maybe 355 days out of the year or thereabouts, not filled with water. And then you get an occasional summer storm or maybe some really heavy runoff from a snowstorm, and you get a little water in that ditch. And the federal government was coming in and saying that they could regulate that particular area based on that law. And I know a lot of people out there may remember that case. Any details I missed? And if I recall right, it was resolved in some kind of arbitration or some kind of out of court settlement. But correct me if I'm wrong on any of that.
No, you're right, and we have litigated the waters of the United States issue in New Mexico a lot. We're taking a case concerning that issue back to the Supreme Court this year. It's called Sackett versus EPA. We've been to the Supreme Court once on this case, but that's another administrative law issue. And we have litigated a lot of cases in New Mexico, a lot of clients in New Mexico, and it deals primarily with administrative law issues because, as I'm sure a lot of people know, land management, the EPA, they have a lot of rules, a lot of administrative regulations, and they love to do things that they're not allowed to do. And they like to interfere with people's ability to make a living and, support their way of life. And so, unfortunately, this is very fertile ground for us, and we've spent a lot of time in New Mexico.
It is waters of the U.S. What could you briefly describe? Is this another just landowner who's got to deal with the waters of the U.S. rule? Briefly describe the case.
Well, it's the same issue, and
Okay.
It's really egregious. I mean, the Sacketts they've been trying to build on their property that they own for a very long time, and the EPA decided that a little part of their land that is essentially a ditch that fills with water occasionally, that has filled with water occasionally, is a water of the United States, subject to regulation. And what's really egregious and outrageous there is that the agency fined them once they built property on that land, thousands of dollars a day, and just basically sent them a letter saying, you owe us hundreds of thousands of dollars if you don't tear down the property you've built up. And then they for years argued that we weren't allowed to sue over that, that it was essentially an idle threat. That went to the Supreme Court. Supreme Court said no, the agency's done something here, and now we're going to see whether they're allowed to do it or not. They sent it back down, and finally we're back at the Supreme Court once again for the real question, and that's whether the agency is allowed to regulate these little puddles or ditches as though they're waters of the United States, as though they're rivers or lakes. And this is a really, I think, an important question along those same kind of lines about what power an agency has, what they're allowed to do, and what they're allowed to do to innocent people who are just trying to own their own property and use it the way you normally would.
All right. Well, thank you for the informational and lively conversation there, Caleb. And thanks for all you and your colleagues at the Pacific Legal Foundation do. I appreciate your time today, and we'll wish you the best of luck in all of these legal endeavors to restore freedom for Americans and New Mexicans. Thanks for listening to this week's episode. Find all episodes at tippingpointsnm.com or at the Rio Grande Foundation's YouTube channel. Subscribe to this show at Apple, Stitcher, or have your Google Home play Tipping Point New Mexico. Thanks to Path 3 Marketing for producing this show.